and she was. Our directions is that she made that application as the Deputy Secretary General of the Third Way Alliance. Therefore, the 1 hour allocated to the Third Way Alliance parties, that is the 7th and the 9th, will be shared with Philista Wakesho. So our time is not 45 minutes, but 1 hour to be shared with the Third Way Alliance because they were pursuing the same issues in the High Court. As regards the participation of the Amici Curi who are joined in the High Court, the position of this court is that they remain Amici, friends of the court. We will consider their submission, whatever submissions were done in the High Court and in the Court of Appeal. We will not allow them time to submit. Those are the further directions of the court. We were told that we need to give this matter all the time, and we agree it is a very important matter. But we have also done research. Supreme Courts all over control their own proceedings and give time allocation. And we have also considered the case that was cited by Senior Counsel Dr. Kaminwa in India, the case, Sanavande case, which was heard for 69 days. We've also looked at the Supreme Court rulings now of the Supreme Court of India. There is time allocation. That was a long time ago when there was no technology, no written submissions. Now we have written submissions. It's only a matter of highlighting the submissions. So we'll give you the time to do the highlight, and we'll read the record of appeal that is before us and whatever was in the other courts. That said, we will now proceed to hearing by calling the first appellant's case, who has 1 hour, and you can indicate the time that has been donated to you so that it's all put together.
Most obliged, we seek leave to withdraw since we have no role.
It's leave granted. Is that the first appellant's case?
My Lady, the Chief Justice and President, may I begin by thanking you, my lords and my ladies, for the opportunity to appear before you and to make these submissions on behalf of the Honorable the Attorney General. And for the record, my name is Kennedy Ogeto, the Solicitor General. And just to confirm, my lady, my lords, you have given us an additional 15 minutes. The Speaker of the National Assembly and the Speaker of the Senate had also donated 10 minutes each. So in total, my understanding is that we have 35 minutes in addition to the 45 minutes that we had originally been allocated.
That is correct.
Many thanks. This appeal raises a number of important legal and constitutional matters. But in our view, my lady and my lords, Issues principally revolve around two main questions. The first question is, what is the import of our written constitution? And the second question, how much and to what extent can we imply meaning into constitutional provisions that are, in our humble view, otherwise conclusive and unequivocal? Our appeal does not just seek the answers to these questions, it also seeks, with equal anxiety, the justification for the answers, whatever those answers may be. Our singular desire in this appeal is that the lingering legal and constitutional questions in this appeal be determined and settled by the highest court in our land, not just for today, but also, and perhaps more importantly, for posterity. Through our oral and written submissions, we contend that the learned judges of the Court of Appeal answered important questions the wrong way, and that they had the wrong, often ambiguous, and in some cases contradictory justifications. It concerns the applicability of the basic structure doctrine in Kenya. My ladies and my lords, that the learned judges erred in holding that this doctrine applies in Kenya. At the outset, we have no doubt that our constitution has a basic structure. No one can deny that all constitutions outlined in Article 255(1) of our constitution. Our constitution tells us that it is amendable. It also tells us how it should be amended. It does not impose its amendability. The Court of Appeal are in agreement, erroneously we submit, with the High Court that the basic structure of the Constitution is amendable only through the primary constituent power, which must include four sequential processes, namely civic education, public participation, constituent assembly debate, and ultimately a referendum. With tremendous respect, we disagree with this position. Neither our Constitution nor its history contemplate the doctrine. We agree with the learned judges of the High Court and the Court of Appeal that Kenya has had a history of indiscriminate constitutional amendments. We, however, note that the people were fully conscious of this while making the new constitution. Page 73 of the final report of the Constitution of Kenya Review Commission, CKRC, captures this concern, and I quote, "Considering how quickly and fundamentally the Independence Constitution was amended, how can we protect the new constitution from a similar fate?" End of quote. And I underline the words quickly and fundamentally. And this report is available in volume 13 of the Bundle of Authorities at page 1753. I have to emphasize, my lords and my ladies, that a plain reading of this report clearly indicates that the problem that was identified during our 2010 constitution-making process had two components to it: quick amendments, mental amendments. Page 75 of the final CKRC report identified the people's solution to this problem, and I quote, "A distinction should be made between entrenched and non-entrenched provisions of the Constitution, with a stringent mechanism being set up for amending the former entrenched provisions." End of quote. This solution is given effect in Chapter 16 of the 2010 Constitution. The procedure for amending the entrenched provisions, which is the basic structure, is elaborate and onerous. our humble view is that judicial intervention ought to be limited to confirming that this consciously elaborate and onerous constitutional procedure is strictly observed and followed in amending the Constitution. The learned judges of the Court of Appeal erroneously elevated the basic structure doctrine to a universal template for certain constitutional amendments or change. This fails, my lords and ladies, to recognize that constitutions are not identical. In our humble submission, where a constitution creates an amendment power that is similar to the exercise of the primary constituent power by being inclusive, deliberative, and democratic, such as is the case in our Constitution, the basic structure doctrine has no place. Problematically, my lords and my ladies, the learned judges do not agree on what the basic structure is. In paragraph 474G of its judgment of 13th of May 2021, the High Court had told us that what constitutes the basic structure will be determined on a case-by-case basis. In the Court of Appeal, Lady Justice Nambuye, for instance, states in paragraph 62 of our judgment that the basic structure of the Constitution is, quote, the Constitution itself and what it contains, end of quote. Lady Justice Okwengu, on the other hand, at paragraph 82 of our judgment, expresses the position that, quote, the framers of the Constitution either consciously or unwittingly identified the basic structure of our Constitution through Article 255, end of quote. According to Justice Kiage, at page 85 of his judgment, Article 255 of the Constitution, quote, either coincides or nearly coincides with what may be considered to be the basic structure of our Constitution, end of quote. Finally, Justice Cairo and Justice Tuyot are certain in their respective judgments that Article 255 of the Constitution outlines the basic structure of our Constitution. Even if the basic structure doctrine was applicable in Kenya, which we dispute, the absence of clarity on what the basic structure is would create much legal and constitutional difficulty. This is a matter that we humbly urge this court to clarify with finality. The second issue I wish to highlight relates to the question of the remit of popular initiative in the constitutional amendment power under Article 257 of the Constitution. In our view, the provision does not discriminate as between private citizens and public or state officers. The route is available to registered voters, who obviously include the president and public or state officers. Our study of the history of this provision is that the popular initiative route was meant to curb the monopoly of Parliament on matters constitutional amendments. It was not meant to exclude certain registered voters or citizens because of their positions or standing in society. And here we rely on the final report of the Technical Working Group, K, of the Constitution of Kenya Review Commission on Constitutional Commissions and Amendments to the Constitution, which recorded as follows, and I quote, "The committee introduced a novel idea called popular initiative. The committee explained that their intention was a starting point towards curbing dictatorship by Parliament," end of quote. And that report is available in volume 18 of our bundle of authorities, page 2622, and the quotation will be at page 4 of the report. Again, lords, my ladies, the learned judges do not agree on the implications of their finding that the president cannot use the popular initiative route to amend the Constitution, or the options available to a president who may wish to spearhead constitutional changes. In paragraph 490 of its judgment, the High Court told us that the president can use the parliamentary initiative route through the Attorney General. Justice Musinga agrees with this position in paragraph 347 of his judgment. Lady Justice Nambuya in paragraph 99 of our judgment, and Justice Cairo in paragraph 81 of his judgment agree as much. On his part, Justice Kiage holds in paragraph 109 of his judgment that the President is under duty to obey but not change the Constitution. So according to Justice Kiage, changing the Constitution is tantamount to disobeying the Constitution. Lady Justice Okwengu, Lady Justice Sichale, and Justice Tuyot do not express themselves on these matters. This absence of clarity, my lords and my ladies. In addition to the foregoing, the learned judges do not consider the consequence of their finding to a president who, having been elected on the platform of arguably necessary constitutional reforms, finds himself facing a partisan and hostile parliament, perhaps because he has a minority in that parliament, or because he was elected as an independent candidate. Justice Kiage, the only one who expresses his view on this point at page 109 of his judgment, terms this situation as hypothetical. We humbly submit, however, that such situations are a real possibility under our constitutional architecture and therefore require contemplation and an answer which we call upon you, my lords and my ladies, to provide. The third and last question, which I wish to briefly highlight, relates to the question of presidential immunity from civil court proceedings. And here the majority in the Court of Appeal held that civil proceedings can be instituted against the President during his tenure of office in respect of anything done or not done contrary to the Constitution. I wish to highlight two obvious problems with this. First, in order to determine whether the President has done or not done anything contrary to the Constitution, there has to be a judicial process. And this defeats the whole essence of immunity, as the President would have to participate in the process to prove his innocence. Second, immunity from legal process recognizes, as a matter of common sense, that the holder of immunity, in performing his functions, engages in conduct that may expose him or her to legal process. If therefore there was the expectation that the office holder's official conduct must always be perceived as lawful, then the whole question of immunity would be redundant. My lords, my ladies, my other colleagues, acting for the Honorable the Attorney General, shall endeavor to demonstrate to my lords and my ladies additional problems with the findings of the learned judges of the High Court and the Court of Appeal. At this juncture, may I, with your permission, lords, my ladies, invite Senior Counsel George Oraro, followed by Mr. Kamau Karori, to present the arguments, and Mr. Nyamodi will deliver our rejoinder at the end of the proceedings. Many thanks, and most obliged.
Thank you, Chief Justice, members of the court. The Constitution of Kenya commences with very powerful words, and that is, we, the people of Kenya, acknowledging the supremacy of the Almighty God of all creations, and exercising our sovereign and inalienable right to determine the form of governance of our country, and having participated fully in the making of this Constitution, adopt, enact, and give this Constitution to ourselves, and more importantly, to the future generation. Article 1 of the Constitution thereafter contextualizes the sovereignty of the people and further asserts that this sovereignty can be exercised either directly or indirectly at Article 1(2). The people of Kenya have further delegated their power to state organs, including the judiciary, as specified in Article 1(3). But the exercise of such delegated power must be strictly in accordance with the Constitution. In the result, the people of Kenya, by their constitutional text, reserved the sovereign power to be exercised directly where it has not been delegated or it is not being exercised through democratically elected representative. And it is in this context that in the CKRC report at paragraph 744, and that is found in volume 13 at page 1851 of our list of authorities, at paragraph 7, they state as follows: all power and authority should derive from the people of Kenya, and the people should be governed through their will and consent. The people reserve to themselves all the power and authority that they do not expressly delegate to the state and its organs. So ours is a participative constitution in which the people are fully involved. It was on that account that in formulating the provisions for amendment of the Constitution, it was recommended at paragraph 746 of the CKRC report, and you find this in page 851, volume 13 of our list of authority. They stated that a number of key constitutional issues should be enshrined in the Constitution, that they should be amended only by a referendum, so that a referendum in accordance with the Kenyan Constitution, as mandated by the people, was an exercise of sovereign power and not a delegated power. It is not strange that that has been incorporated into our Constitution, and indeed, in the famous case which has been relied on to justify the basic structure doctrine, the case of Njoya, it is always stated that at that stage the basic structure doctrine was recognized, but Njoya also recognized the textualization of the sovereign power. And you'll find that in our list of authority at page 24, where in Njoya, this is what Justice Ringara found. The second stop is recognition that sovereignty of the people necessarily betokens that they have a constituent power, the power to constitute and or reconstitute, as the case may be, their framework of government. That power is primordial one. It is the basis of the creation of the Constitution, and it cannot therefore be conferred or granted by the Constitution. Indeed, it is not expressly textualized by the Constitution, and of course it need not be. If the makers of the Constitution were to expressly recognize the sovereignty of the people and their constituent power, they would do so only ex abundante cautela. And that is what they did in our Constitution. This case was in the repealed Constitution, and in the new Constitution, they now ensured that they textualize the sovereign power of the people. The Constitution of Kenya thus places the people at the core of constitutional operation and enforcement. And for that purpose, it incorporates a very permissive amendment provision under Article 250, granting the courts the power to advance the contemporary aspirations of the people, with this court as the final arbiter. And that is where we are. The direct democracy, which is referred to at Article 1(2), is exercised through the national values and principle of governance pursuant to Article 10, public participation in legislation for Parliament, Article 118, and for county assemblies, Article 196, and finally, in constitutional making through popular initiative, that is Article 257, and of course, public discussion in amendment by Parliament at Article 256(2), and finally, that sovereignty is exercised through a referendum to amend those matters which have been specified at Article 155(1) by the provision of Article 255(1) by the provision at Article 255(2). It is because of this peculiar character of our Constitution that this court, in dealing with the amendment power under Article 259, had the following to state in its decision in petition number 13A of 2014, Judges, Magistrates Vetting Board, and 2 others versus Center for Human Rights and Democracy, and 11 others. This is what this court had to state. It stated that although certain jurisdictions such as India and Germany have perceived judicial review as an immutable structure of their constitution, and hence the basic structure doctrine, these jurisdictions do not have constitutions that are as unique as Kenyans. We must ask whether these foreign jurisdictions, 159 and 259, and I would add to that 257 and 255, which emphasize the sovereignty of the people, or whether they have principles and values like the ones found at Article 10, which apply to the interpretation and application of the Constitution, or whether they have legislation similar to our Supreme Court Act, Kenya's historical context into the interpretation of the Constitution. If the answers to those questions are in the negative, and indeed they are, then the common law doctrines found in other jurisdictions, foreign cases, and foreign constitutions must be interpreted in such manner as to reflect our modern Constitution and our unique conditions and needs. And that's what I'm requesting this court to do. Look at this purported introduction of limitation to the Constitution by a foreign doctrine and find out whether in the context of Kenya today, this doctrine can apply to what the people had determined to be applicable to them. That notwithstanding, both the High Court and the Court of Appeal found that there is a limitation to the constitutional amendment powers under Chapter 16, Articles 155, 156, and 157, read together with Article 1 and with very permissive provisions under Article 259. The said finding was based on the following grounds. First and foremost, the court found that the basic structure doctrine is accepted in Kenya following the decisions in the case of Njoya and Attorney General, the case of Onyango and 12 others versus Attorney General, and you will find that at page 28 to 121 with the relevant portions of the judgment at pages 67 of Volume 1 of the Attorney General's authorities. These were all cases decided under the repealed Constitution, and I will go to that in detail, but I would start by commenting that under the repealed Constitution, there was a single tract amendment provision which placed all the power on the Parliament to affect amendments. Under that Constitution, Parliament was purporting from time to time to overturn the basic structure without reference to people, and therefore, in that context, the basic structure doctrine applied. But does it apply in our current context which has a multi-tracked amendment provision, as we will show you. The other decision they relied on was a decision in Commission of Implementation of the Constitution versus National Assembly of Kenya and two others. It was a decision by my learned judge when he was in the High Court, and it was based on an attempt by Parliament to alter a provision which was entrenched under Section 151, and the issue there was limited to the power of Parliament to amend. Now, contrary to those decisions, the courts subsequent to the amendment of the Constitution and before the decision in this case, in the case of Priscilla Ndululu Kivuitu and another suing as personal representative of Samuel Mutua Kivuitu and Kiara Mutu, my ladies, you find that at page 142 to 182 and at page 177, found that the basic structure doctrine is not applicable to Kenya in view of the amendment provisions under the new constitution. Though this finding was obiter, but that was the finding of the court, 3 judges. You find that at page 142 to 182, and the relevant finding is at page 177, volume 2 of our authorities. The Court of Appeal has been more succinct, and in the case of Senate and 48 others versus Council of Governors and 54 others, 2019, you find that at page 183 to 202, at page 154 of volume 2 of our list of authority, they expressly found that Kasavananda no longer applies to Kenya in view of the new constitution, a bench of 5. Again, in the case of Attorney General and another versus Randunzai, Rua, and five others, they came very succinctly and expressly, and now clearly stated that all the provisions of the Constitution were amendable so long as Article 255, 256, and 257 are followed. And you will find this case in our supplementary bundle. The relevant finding is at page 19. Due to time, I will not read it, but if I get a little time, I'll go through it. Now, there was clearly a contradiction between the position now held by the court in this case, granted this power to reconcile these contradictions and come up with a very clear position where any limitation to amendment power as granted under the Constitution. My humble submission is that there is not, because as the SG had stated, the provision of amendment under the Constitution are very clear. The other ground which they relied upon was that an amendment provision in a constitution are secondary, powers granted by the exercise of primary constitutional power, and cannot therefore alter or amend what has been created by people exercising their primary constitutional power. This is based on a constitutional doctrine which was later advanced to the doctrine of basic structure as articulated in the case of Kasavananda in India. However, the Kenyan Constitution has distinguished between the matters which can only be amended by Parliament or popular initiative followed by referendum, and those which can be amended by Parliament and therefore not listed under Article 255(1). The Kenyan Constitution provides a strict procedure for those matters which have been entrenched under Article 255(1), and which can only be amended whether by Parliament or popular initiative, but through a very intensive process involving consultation with the people, and that's the only place in the Constitution where the issue of public discussion is incorporated. Article 256(2) requires that before Parliament passes any constitutional amendment, there has to be publication and public discussion. And that's not the end. Parliament has then to pass it with requisite majority, and it is only after it is passed by that requisite majority that it is then taken to the people for a referendum. And that referendum has a threshold higher than presidential elections.